All right. Good morning or good afternoon, everyone. Welcome to the National Center for Medical Legal Partnerships Health Center Planning, Implementation, and Webinar Series. Again, we are partnering with Texas A&M Health Institute, Health Institute for Healthcare Access, Today is April 18th, 2024. East Coast, you're joining us at 1 p.m. On today's webinar, number 5, where we'll talk about how to develop a strong memorandum of agreement for a medical legal partnership. Welcome back. I'm Bethany Hamilton, Director of NCMLP. Some quick housekeeping. As always, you're joining on mute, but in this webinar series, we are interactive. So you can use the raise hand feature at certain points to engage in conversation with us. You can also use, and you'll be encouraged to utilize the chat, the Q&A, but we will be interactive. If you'd like to display captions, you can use Zoom to select live transcript and show subtitle to have captions appear on the screen. And the answer is yes, because we know you'll ask. This webinar is being recorded and will be shared on the medicallegalpartnership.org website under the resources section. Some more housekeeping. Just want to remind folks as to how you'll be either reminded or told that we have a chat point when you can unmute. So you may see the symbol throughout the webinar series where we're going to let you know, heads up, raise your hand to unmute so that we can actually ask you a question or get you to respond to some lesson in the webinar for the day. At some points during this icon that we've created. If you're joining us perhaps for the first time, we have some acronyms or alphabet soup. And so we want to make sure that everyone knows what the alphabet soup really means. So if you hear us say MLP, we are talking about medical legal partnerships. Also, some of you may be using health justice partnerships, health justice alliances, interchangeably using MLP. CHCs, if you hear that, we're talking about community health centers, and we're referring to the HRSA or Health Resources and Service Administration programs. For those of the health centers that qualify for it or according to their grant or as lookalikes, we refer to them as FQHCs or federally qualified health centers. And then for certain legal aid organizations that receive LSC funding, by LSC, we're referring to the Legal Service Corporation. As mentioned on the previous screen, this is a HRSA or Health Resources and Services Administration funded resource that we're providing to you. The National Center for Medical Legal Partnership is in its 10th year of cooperative agreement partnership with HRSA. And it's through that funding that we're able to bring you several of these resources. Again, this webinar series kicked off in February. If you're joining us for the first time, welcome you back, or excuse me, welcome you. And if you're joining us again, we welcome you back. Forgive me, folks, for tripping up on my speech today. We are partnering with Texas A&M University's Institute for Healthcare Access. I'll introduce the speakers today. We're also joined by another faculty member from UCONN, helping us walk through our Health Center MLP toolkit. Speaking of, we encourage everyone participating in this series to use that Health Center MLP toolkit as a resource. We're walking through it conversation by conversation, step by step, to ensure that everyone has what they need to plan or advance their existing medical legal partnerships. So we have a poll. I'm going to ask Reha on the NCMLP team to go ahead and launch the poll. We want to make sure we know who's actually joining us today. We know the group tends to return from previous webinar that we've hosted. For today's webinar, what type of organization are you from? From healthcare, legal services, academia, or perhaps other? And then, does your organization have a medical legal partnership or MLP? If you don't know, that's okay. Just let us know, yes, no, or perhaps you're not sure. And as it pertains to today's conversation, if you do have an MLP, tell us about the contractual document that you use to demonstrate organization. If MLP, which documents are you contemplating or familiar with? Go ahead and choose all that are applicable. This last question is choice, so perhaps you use combination of MOUs and MOA, a BAA or business associate agreement, or some other type of document to demonstrate some organizational commitment. All right, I think we have about 72% participation. Let's allow folks to wrap up in about 5 seconds with their responses. And let's end the poll and share the results. It's great. We have a really nice mix of healthcare and legal services joining us today, along with folks from academia and other. For the people from the other category, let us know in the chat where you're from, what type of organization you represent. Also awesome to see the number of medical legal partnership folks joining us, as well as folks without an MLP and those who aren't quite sure yet. And then it's interesting what folks have answered in terms of whether they have an MOU or MOA, a BAA, or some other type of document to the commitments as partners. So most of you actually do have or MOA in place. That's great. Some of you all have BAA. We'd love to hear from you how you're utilizing those. And then for the folks in the other category, let us know as well what type of documents you are referring to. So we're going to stop sharing the result. And as you can see, we are again on part 5 of the how do we develop a strong for the medical partnership, and we'll continue with the webinar series of June. For today, we have the following learning objectives. We're going to just setting by explaining an MOU or Memorandum of Understanding really is and how it operates. We're also going to demonstrate examples of important terms in and considerations of an MOU. And then finally, we're going to analyze the relationship of an MOU to a BAA or business agreement. And apologies, folks, I understand my audio is a little bit choppy. So let me know as soon as you can. And thanks for giving me a heads up. Apologies, it's my internet. All right, I will soon be passing it on to faculty who have much better audio and no internet problems, we hope. So, Keegan Warren, Executive Director of the Institute for Healthcare Access at Texas A&M University's Health Science. You'll hear less from me today, but for Medical Legal Partnership, and as promised, we have an additional faculty member from UCONN actually joining us. That's Adjunct Professor of Law, Jay Sicklick, who's been in the partnership field since decades now. He's one of the medical practitioners and is a former MLP director for Patrick MLP. Welcome back to both Keegan and Jay. Also, you heard me refer to Reha Manikanasamy, our scientist here at NCLP. Go ahead and send us an email if you need any help, or feel free to send a chat if you need any assistance or resources throughout the series. And let me just do a quick session for recap. So the last time we met, we talked about how are we going to pay for a medical legal partnership. This is about more than finding funding. This is about ensuring that you're also developing a comprehensive budget. So last time we were together, we talked about the common sources of legal and healthcare funding for MLPs. And then we talked about how to evaluate to what extent your budget actually captures all of your revenue and expenditures, including the wish list. And then finally, we your budget and how it might reflect programmatic values and ensuring sustainable road. See on this down some of the topics for building sustainability, about the partners, how to allocate direct funding for the future, starting small with philanthropic investments, and how to allocate sources to support both pilot projects and being able to collect data in your MLP work. We talked about anchoring activities in your budget to grow. And we also talked about legal funding resources and how herself can offer much more in terms of sustainable funding for medical legal partnerships. And then we talked about health center funding, the health center model, and how they included medical legal in their grant proposals as Section 330 grantees. So thank you for joining us again. I asked to Keegan Warren to have today's conversation about MOUs and MOA. Keegan, all yours.
Thank you, Bethany, and welcome all to today's conversation. I think that as we kind of thought about how to frame this conversation, one word stuck out for me, and that was that this is a bit of a finite topic. And so we're really hoping to have a robust conversation today. And so if something strikes you as salient, please do not hesitate to raise your hand and to jump in. One other note about this topic is that it does absolutely relate, and I think you'll find this to be continually true. It relates to the previous conversation. So as we're thinking about the contractual document, that may be influenced by your staffing model. And so for you or your organization, there may be things that we'll say today that don't quite apply. We'd love to hear those insights. Your budgeting, if you are entirely health center funded, for instance, there may be some ways that shapes the contract as well. So we're going to try to highlight all of that, but we'd also really love to hear from you all, as I said. The other upfront bit of framing that and level setting that we wanted to do was about what the document's called to begin with, right? Some people say MOA for Memorandum of Agreement. Some people say MOU for Memorandum of Understanding. We're going to use MOU today, but it's our experience that different MLPs use different terms, and that it's really not that important. That at the end of the day, what matters is the substance of the document, not necessarily what you call it. If anyone disagrees, again, please feel free to jump in. But that is, I think, and Jay, I would invite you to jump in and tell me how you see this. I think that's our starting point for today. So we're going to use MOU, but it doesn't mean that we're not referring to MOAs or whatever else you might call your document. So I am going to ask Jay if you will jump on and do a little bit of a recap for us about the contracted model in particular, because I think that is where these documents are probably most used.
Yeah, thanks, Keegan. Good afternoon, everybody, or good morning potentially from wherever you are. I just, I'm going to reiterate what Keegan said about what you call it. As someone who has gone through numerous iterations of these contracts, and for all intents and purposes, these are contracts between two entities that are working together to formulate and build from a foundation of a project. In all the iterations, in all the partners that I worked with over the years, we never called it a memorandum of understanding or a memorandum of agreement. It was only just agreement or, some other type of document. So again, I think it's, potato kind of thing, but the substance, and that's what we're really going to focus on, some of the key elements, some of the key provisions. And when you have that contract model, by definition, usually it's the health center entity who initially provides the kind of mandated requirement that you need to have some kind of agreement in order to facilitate this partnership with us, because you're ostensibly coming into our home and working. And that's kind of at least a number of years ago, that was more of an oddity rather than the norm. I think as hospitals and health centers have expanded services by welcoming in community partners, this is perhaps a little less daunting than it was a number of years ago. But the principle still applies that if you're dealing with two entities that are not under the same umbrella, you're going to need some agreement. And the more that I got involved in this over time, the more it became clear to me that this was also an opportunity to protect the L side of the partnership as well. Protect and expand and enhance. So it's got so many different variables. And again, I think Keegan was pretty upfront about this. This isn't the you know, kind of fanciest, or if you will, kind of most, you know, sexiest of topics to talk about. It brings probably a number of you back to contracts, but we'll try to avoid the nomenclature and some of the esoterica and concentrate on the substance, because that's really where it's at. And in that contracted model, this is, again, a foundation and an open book, if you will, to start thinking about or enhancing for the next contract. What are some of the terms that we want implemented? And should we really worry about some of the terms that the partner has asked us to put in there? And I think we'll try to at least, you know, fortify some of the confidence that you have and dispel some of the concerns also along the way. I'll take this one. Sorry about that. So again, most of you, I think, can follow along, and I think, you know, again, we've all, those of us who've done this, have used some iteration of the memorandum of understanding, which is, again, we'll use that as a term of art for this conversation. The MOU basically is the document that, at least from the past, was, as I said, driven by healthcare administration, but it does set forth the opportunity to provide for all who read it and all who are adjacent to the project. And that goes pretty far, usually in the health center side or the health administration side, to put down what your goals and missions are of the project and of the partnership. And the first part that you get to do this is in the first part of the document, which is called the preamble, or a little bit more technically from the contract side, the recitals. And those of you who are familiar with contracts or who have dealt with this over time, the recitals are the opportunity basically to spell out the why, right? Why are we entering into this contract? And what are the, you know, specific scenarios that will, you know, have come into play that will allow us to really spell this out? And, you know, even though they seem like formalities, I think they're really important. And, you know, for, you know, again, without kind of delving into the, you know, specifics that you are mandated, put the phrases in there and put the opportunity. This is the opportunity to put in, what does your organization stand for, right? So if you're from the legal organization, say that you're dedicated to, and this is just an example, fighting for the legal rights of vulnerable populations, of children, of people with disabilities, of whatever it might be. If you have legal services organization, disability rights, children's legal rights, whatever it may be. What has the medical legal partnership? What is it that you want to accomplish? You want to improve health outcomes. You want to deal with health inequities. You want to deal with individuals at risk and target better access, whatever that may be. The partners want to recognize the collaboration between them so that they can assist together in collaboration of advancing the health outcomes of your population, the population that you're dealing with, whether that be, again, pediatric, adult, again, what palliative care, et cetera, et cetera. The two parties wish to collaborate by providing services on premises at the home of the medical entity, right? That can go in there because these are all the why. Why are we doing this? And the basic, and this is another phrase that I think that you might want to consider, is that the basic autonomy of your organization and the health entity is maintained and shall not be altered by this agreement, et cetera, et cetera. There may be phrases within the confines of the document that we'll get to in a little bit that say that, but the recitals are the purpose and the goals of the document, and more importantly, the mission of the partnership. And this is a good opportunity. And again, you know, I know the toolkit has some. There's probably some online. Keegan, I think, has generously agreed to work with folks. I know she does that professionally as well, and I will as well. I'm happy to share documents, you know, appropriately with folks if they would like to take a look at some of the recitals or again, anything else we're talking about. So number one is, what are we starting with here, right? What is the first point we want to get across? We want to get across the mission, the goals, and the potential outcomes. I think we can go to the next slide too. No, I can. I'm happy to start, and then you can jump in. But so the next. So now we're going to get into the meat and potatoes of the MOU, right? These are really the key. Maybe I should stop there, and maybe we should just posit an opportunity for anybody who has any comments or questions about, kind of starting one of these. What are the outcomes, goals? Have people done this a different way? Because we don't want to kind of co-opt the entire program. If anybody has any comments or thoughts or anything else that we may have missed or that we kind of brushed over with too fine a brush.
So feel free to raise your hand. Can we actually go back to the preamble and recital? Is that what you're thinking, Jay? These are the parts that or may well start with the whereas clauses and then kind of concludes. I know in some of mine, in furtherance of the foregoing, the parties hereby agree to the following, right? Like we can be really formal with this language. It can also be really casual. So if anyone has any insights they'd like to share, any moments, any aha moments that came from just this kind of being purposeful about this introductory language, we'd love to hear it. Otherwise, in furtherance of what's been said, let's move on.
We can also ask if anyone actually is brave enough, perhaps to share if they took a look at their MOU before joining today's webinar, or if anyone wants to share perhaps the statement of purpose so that we can hear and they can show off a great statement of purpose.
Yeah, if anyone, while they're pulling it up, I can actually read the one that I use because I have helped a number of MLPs get off the ground and firm up this language and kind of walk through what their MOUs look like. So my kind of starting point for this conversation, it really does start with whereas because it entertains me. Whereas to further its mission, the medical entity, right, desires that the legal partner, the legal entity, provide services to the medical partner's patients, trainings for their staff, and integrate structural competency into the clinical activities in alignment with the National Medical Legal Partnership Model as more fully described below. So pretty short statement, but kind of queuing up that these are going to be individual services, that we are going to do trainings, that we're really, but we're also remembering that MLP occurs along a continuum, right? It has that, I've been doing some conversations with social workers lately. It has that meso and meso, and right, the socio-ecological model that goes from the individual and gets bigger and bigger. In MLP, of course, we tend to say patients to policy. So I like to bake that expectation into that initial statement of purpose.
So just in case someone's trying to find their MOU to show off later on, no problem. We'll come back to it. So just letting folks know if they want to still share and respond later on to this question that we're posing about what's in your preamble of your MOU or any successes or challenges related to development thereof. We can always come back to this. Just use the raise hand feature in Zoom so that we can see you and unmute you. Or we're also, folks, you're welcome to use the chat. Keegan and Jay, let me know which slide you'd like to go to next.
Let's go ahead and move on to legal services responsibilities, because I think these next two sections kind of go hand in hand. One is laying out what are the expectations we have for the legal partner, and the next one goes into the medical partner. I think there are pieces of each that are unique to whether you are a law firm or whether you are a healthcare clinic or hospital. But there's probably some opportunities to make sure that you're also aligning this work, that you're thinking about, well, the goal isn't just to create another source of referrals for the legal aid organization, right? But rather it's to multiply that frontline capacity. And so how do we align the language in a way that helps us achieve those goals, that helps us achieve that statement of purpose? So you will often see in the legal partner section several things. One, who's in charge? Who are your points of contact on the legal side? For the legal organization? What are the duties of the folks who are on the ground? Because sometimes that's not the same folks. You may have a supervisor who's in your main office, but the people who are entrusted with doing the everyday work of the MLP may be different. I will mention again later, but I'll say it here as well. Defining who those folks are is, you know, a matter of hiring and all of the due diligence that goes along with responsible hiring for the legal services organization. But they're going to be on site in a different organization that may well have input or want to have input or want to have some kind of line of sight on that hiring process, just because they're inviting an employee of a different organization into their facility. So yes, this is kind of a responsibility of the legal partner, but a piece of that may also be to allow the health center to do due diligence around the folks who are going to be working with the patients that they've invited into their building. We also see here very often language around technology and access, language around a requirement to ensure that there's professional liability insurance. That tends to be something that's only easily accessible to the legal services organization, even though the healthcare entity does carry various types of professional liability insurance. It won't necessarily, well, it almost certainly won't extend to the practice of law. Now that doesn't mean that they may not choose to add that as a writer, but that's a piece of the conversation that needs to happen. And most often, I think it tends to fall to the legal partner. And then the other big topic provision that is provided here is a chance to explore the distinctions between the physician-patient relationship and confidentiality and the attorney-client relationship and confidentiality. And I think that I think you'll hear us say this more than once over our time together here, because our professional ethics, our professional values, as between lawyers and doctors and social workers, right? That's three very different approaches to confidentiality and to working with a person versus working with a family. And so a lot of that can be documented in this section of the MOU as well. Let's see. So the other things that may go here, I mentioned the professional liability insurance or malpractice insurance. Reporting. Does the legal services organization have a requirement to report that you'd want to include for the healthcare entity? I think it's worth saying to all of you who are with a healthcare clinic or a hospital that it's fairly typical, I think, for legal services organizations to have a reporting requirement to a funder. And so what does that look like in the context of your MLP? I can also tell you as a FQHC director, that with that hat on, we get regular reports. We actually get monthly reports on the services that are being provided on each line of service, and that comes in monthly. And that includes the MLP report, right? And so these are spaces to have a conversation about where is this data going to show up? How can you use it to promote the program and the amazing work that's happening? And I think documenting that and having that conversation up front is the real opportunity. The other couple of other things here, the BAA, the Business Associate Agreement, which we'll kind of call out as a separate matter at the end of our time today, is often invoked in the section regarding responsibilities for the legal partner. And that's simply kind of a reiteration and of what the BAA says. And making sure that the MOU is not inconsistent with the BAA simply because the BAA is a requirement under federal regulations for healthcare entities. The other thing that we've seen, and Jay, I'm gonna ask you if you have any other insights here, are a concept that that I think most of us have most recently heard in the when it comes to the NCAA and to like basketball players or football players, right? That NIL, the name, image, and likeness, or name, logo, and likeness might be a more appropriate way to think about it here, because the healthcare entity and the legal entity both may well have branding guidelines. And yet here you are as partners talking about the other organization. So, what does that look like to talk about the work at another organization, to use their logo in a press release? Have that conversation up front and spell that out as well in your MOU.
Yeah. So that one is really important for a number of reasons. If you take a step back and think about the opportunity to enhance the project by utilizing the joint logos or the joint representations, you're going to need to develop, if you haven't already, a good relationship with the folks who are in charge of the proprietary nature of those logos and the communications folks usually. But it also, goes to some of the points we're going to talk about a little bit later, is that, how are you going to project the project, if you will, without using the word too many times in one sentence? How are you going to hold yourselves out as an entity? Is this purely the legal side going to work on a particular issue? Is this going to be a joint effort and endeavor, and how does that potentially involve issues somewhere down the road of responsibility, liability, et cetera? Those are dealt with in the MOUs as well, as we'll get to. But these are just things to think about, and just be circumspect before you kind of run into the fray with a new name or a new logo without really thinking it out and hammering that out. All of these sub-bullet points that Keegan had gone over are really just suggestions. The models really are just that. They're opportunities to pick from the menu, and then you can plug in which is most relevant to the entity, right? And to your joint entity. So think about that. Most of them are pretty reusable, but think about, you may not be in a position where you're going to use each other's logos. That may be a non-starter for some, so obviously, but think about what you should do. Think about some of the language that you'll be able to look at, tailor it to your own needs, and finally, the reporting requirement, while burdensome, trust me, it's burdensome. And if I had a dollar for every time the attorneys that worked with me complained about the reporting, I'd be richer than Caitlin Clark. But I will say that it is your ticket to things like contract renewal, establishing the foundation for data and efficacy of the project. So even though it becomes a burden on the folks who are the legal entity, it's really important. But annual reporting, I think, is the way I would go, and everything else can be done informally, but certainly on a schedule.
Yeah, I think that, if I could just jump in, I think that's the key, is have that conversation and make it a jointly determined schedule. So if anyone, I want to echo what Bethany said, but Jay, can I ask you a question that came up? So Margaret, and you, please feel free to raise your hand and we'll unmute you to elaborate. But she says they don't specify the exact staff makeup. And so I'm wondering, Jay, if you, in your experience with drafting MOUs, with launching MLPs, have you found that there is a reason to specifically identify staff member from the legal provider, or if you think that there's benefit to leaving it more vague?
I would agree with Margaret and side on the latter, because again, part of the agreement as we go forward may, or as part of this responsibility might be having the entities jointly responsible for the selection of individuals in the project that might or might not be a particular term in the contract. But I always erred towards the side of keeping that as vague as possible and allowing the kind of proprietary nature and the responsibility of the legal side to really have the authority over who's going to be doing the work, as opposed to this is the framework of what we're going to be doing, and that there will be personnel in the entity that will then comprise this joint exercise. So I personally think it's more, and again, the healthcare entity may or may not agree to that, but I think, you know, Press, this is the responsibility of our side to identify and provide the resources we need that will fulfill the goals of the agreement. So I think it's probably you get a lot more flexibility being a little bit more vague in that context and not necessarily specifying, you know, it will be one person, two persons, whatever it might be, because things happen. You know, people go on halftime, you want to split the line, there's another grant that comes in, who knows what it could be. And so keep the flexibility and the opportunity to amend on the fly and to, you know, and to call an audible as things are going. I think that's probably gives you and the entire project more flexibility.
I think the one piece there I would highlight is that sometimes healthcare entities can be, they can have roles that require specific identification, not maybe by name, but a process, to have a clear process so that they know who's in the building. And in that case, I think I would second broadly this idea that leaving yourself space to recognize the realities of supervising the practice of law, that's not something the healthcare entity can do. And so the law firm needs to be able to do that. But you still may have to work around the health center's processes that are around security. And in that case, I think the opportunity in the MOU is to spell out what is the process for identifying who is the language that I've often used is an authorized MLP employee, right? Recognizing that that both entities have responsibilities to their staff and to the patient clients. But without spelling out, like specifically it's this person. So again, I think the issue there depends on if someone's on site in another building frequently, you know, with regularity, or are you talking someone remote?
Yeah, I think it's going to be a given. And those of you who are, you know, involved in this for a while understand that the personnel who are going to be working in the healthcare environment will by definition have to comply with certain requirements, whether that be security, whether that be background, whether that be going through orientation like employees do. Those are very standard and appropriate. And again, those aren't worth putting up a fight about. And those should be written into the agreement in some fashion, that the expectation is that anyone who comes to work for, you know, any significant period of time, I'm not talking about someone who's delivering a, you know, a file or something, but anyone who's going to be part of the project is subject to the following requirements. And that's exactly what Keegan was talking about. That yes, we'll do the orientation, we'll do the background check. We have to, you know, ensure that they comply with the, you know, potentially the healthcare requirements that folks in the entity, the PPD and the, you know, the COVID test, whatever it might be.
Vaccinations, HIPAA trainings,
Correct.
those are, yeah. super common, and those may be reasons that, again, I would focus on the process, not on the specific identification. Okay, let's talk about health center responsibilities. We've spent quite a bit of time on legal, and it would invite more questions and comments and observations. So responsibilities of the medical partner as the host organization may look a little bit different, but keep that framing in mind that Jay and I just kind of laid out for you, that you have, as a legal services organization, the responsibility for hiring and supervision and et cetera, but that the healthcare entity is hosting someone else, kind of as a quasi employee almost. I don't mean that in any kind of legal sense. For once. And so, so this is an opportunity to spell out who are the health center folks who are going to be champions, who maybe have that protected time that we know helps make an MLP successful. It may be a place for the healthcare entity to guarantee that they're going to offer confidential space to the legal team. I have found throughout many years of doing this that although funding is a question that people always have, space is frequently the major delimiter on expansion. So have that conversation up front. Have that conversation when you're renewing your MOU. Sometimes, particularly, and it starts to get at another question that's come in, if you are doing a pilot, it may be that not all the healthcare clinicians or lines are empowered to refer patients to the ML legal team. And so maybe you want to spell out up front, we're just going to focus on pediatrics, or we're just going to focus on our community nurses and our community health workers from this part of the county or this zip code, rather than all of them. Et cetera, right? So you can put that plan into place in your MOU. This is also a great place for the health center to be really upfront about what resources they are going to provide, what access they're going to provide. So I think, in my mind, ideally that does include the electronic health record there. But is that read-write access, or is that read-only? You know, and if so, do you need to use their computer? What does wireless access look like? What does telephone access? What's copying and printing, et cetera, right? So you can put those dedicated resources in here as well. It's another good opportunity to have that conversation around privacy and confidentiality, and figure out a way to marry the expectations of both the healthcare field and the legal field, because we start from two very different places. And then finally to talk about how you're going to center on the patient. What does informed consent look like in this space? Both healthcare and legal entities are use that as a starting point in their separate work. So in the context of collaboration, how does that change? How do you bake all of that into that space? Jay, did I miss anything? Is there anything you would add about health center responsibilities?
No, you got to the second page. So, you know, all of these again are, you know, originally, just by way of anecdote, these were, you know, initially this was a much smaller list. So as I was looking at the slides and Keegan and I were going through to prepare, you know, more and more things came to mind over time. And I wish that we had included some of the terms that are represented in the bullet points here in some of the original agreements. I just want to reiterate a couple. Again, everything is tailored to what your you know, what your opportunities are and what the logistics are. But boy, if there was one that I would tell you to really go to the mat on, it's the confidential space. Because that is at such a premium, and I'm sure all of you in the healthcare side know, it's a premium at all healthcare entities to find space for anyone who's doing anything. But this is really important, and there have been too many times that I've heard both anecdotally and directly that there's just no space for the lawyer. There's just no space for the law student. There's no space for the whomever it is, the intake coordinator, et cetera. And that becomes a problem because then there really isn't the opportunity to, you know, enhance the initial part of the relationship that will begin right there. Again, you know, it's not easy to ask a healthcare clinician to, can you leave the room for 10, 15 minutes while I conduct a, you know, confidential intake with this particular individual. That's just not going to happen in that entity. It's very different than in your office offsite. So if you're you know, if you're thinking about this and there's the opportunity, even if it's something that's less than optimal, I would certainly do as much as you can to guarantee that, and to have a conversation with the partner about the opportunities that are presented to learn about the relationship that the legal entity is going to have with the patient client as opposed to the healthcare entity. And so how does that work in real time? So those are the things that, again, all of these are really important, but I think for the most part, we've covered pretty much everything you need to know on these 2 slides. Any questions, any thoughts? Did we miss something? Did anybody put something in that they're glad they did, or maybe on the converse that came back and, you know, was detrimental, and you were like, well, next time we do this, we're not going to do that. Anything that people can think of.
And Jay and Keegan, this is Bethany. We had a question that actually came in about process that may be relevant here. It's in the Q&A related to the BAA requirements. Do you mind if I uplift that?
No, please.
Thanks. All right. So the question is, the BAA requirements can be really significant for the legal aid providers in particular. Is it common to have a process to obtain individual PHI authorizations from patients rather than a BAA?
So I would want to hear more about this. I know that this was an anonymous question, but I'd still like to hear more about it because I think the answer is yes, but it's probably a yes and. Right? Like, yes, it is really common for there to be an individual PHI authorization, but it's also really common not to necessarily have that fully written document simply because the reality is that many healthcare appointments are 10 or 15 minutes. And that framework was designed around answering a single medical question. And so when you add in those other layers, it can disrupt workflows, and that can make it hard for the healthcare team to meet its definition of productivity, right? So I'm really curious what BAA requirements the legal organization finds onerous, because my experience is that they're pretty straightforward and almost not applicable. Jay, have you had a different experience with BAA requirements?
No, and I think that I honestly think that well, again, you know, I don't want to answer the question without knowing all the facts, kind of thing, you know, to be really uber lawyerly about it. But on the other hand, I can't remember. Let me put it that way. There being a time where we didn't agree that, you know, that we signed the BAA, and BAAs are signed as a matter of course. It's not just us, it's all the contractors so don't feel like you're being singled out with the BAA. You know, they're the food service people, they're the, you know, and whatever entity comes in and does any of the contracted work in a health environment, that they're BAAs for that. On the other hand, we always felt that having an additional opportunity to enhance the evidence, if you will, that there has been a appropriate authority to share that information on a separate document is critical. It's really important, and it protects you as a legal entity more than anything. So even though it might be slightly onerous, I think the process can be streamlined without getting into too many details, and we're happy to share that on how you can do it. Whether it be through the EHR process, whether it be through a form, two-sided, whatever it might be. And that became a standard kind of de rigueur practice for all the entities that I was involved with. And we just made it part of the routine for the legal providers, because then I think it also assuages some of the concerns from the healthcare side that, does this really provide the type of authority and opportunity to gather that PHI? So we used appropriate releases always before, and really kind of delving into some of the specifics.
Keegan and Jay, another great question came in chat. It's still pretty common for us to hear the following. And so Haley's sharing, on behalf of many around the country, if the client signs consent on both sides, on both a referral and a legal retainer for the MLP to share an acceptance, denial, as well as outcomes with the referring provider, does that negate attorney-client privilege?
I'm happy to give that a first shot, because I think the answer is, for me, pretty clearly no. We as attorneys talk to third parties about our clients all the time, and if I'm negotiating for that asthmatic patient to have their landlord come in and clean things up, I have to admit that I have a client, and I have to admit that they have a medical condition, and et cetera, right? And so I don't think we would say that having the client's permission to share that information, which we may not even actually necessarily gather through an express, like a written document, we might talk to them about it. I think that's kind of baked into the rules of professional responsibility, as not the model rules, I should say, as not negating the privilege overall, but rather as being part of advocacy. Jay, what do you think?
I couldn't agree with you more. And I do think, this is where, again, I don't want to get too into the weeds on professional responsibility, but it is something that I teach at the law school. So it's a little bit in my wheelhouse, and I worked on some of these issues many years ago with a lot of really folks who were smarter than I. But I would say absolutely not. Allowing the sharing of information within the context of a particular case in no way, shape, or form abrogates the attorney-client privilege, which, by the way, is so narrow, don't overstate it. It's just a testimonial issue. So it's an evidentiary piece. But the broader piece that I think Keegan was talking about is the confidentiality guarantee. That's pretty much Rule 1.6 in most of your rules of professional conduct, allows, by definition, the lawyers to share information that's reasonably related to the case, as long as you're not revealing information that is, in fact, confidential. And, that's within the discretion of the lawyer. I take a much broader view than perhaps some of my colleagues over the years, but it's baked into the rules that it is absolutely reasonable to share that information, frankly, even without a release, but especially with a release that's narrowly tailored to this particular issue. And again, if a lawyer doesn't feel comfortable sharing confidential information back to the team or to the healthcare entity, the lawyer has that inherent right not to do so. In fact, an obligation under the rules of professional conduct, under Rule 1.6. But if it's general information that is part of the process of relating to the representation, then I think you're well within the boundaries of sharing that information. You're certainly not violating the attorney-client privilege whatsoever, because it's not information that is kind of, anything that has been authorized that be above and beyond what has been shared. And it's permitted by the rule of professional conduct specifically, and you have that additional support within the confines of that release that allows that two-way sharing of information. So I would say already way over time, making it a lot longer than I think I wanted, but to reiterate, I would not have that concern. I don't think you're in that territory. And there are times where you will not share information, and you should not, but that does not in any way prevent you from sharing the information that is certainly related to, for example, an outcome of the case, or something that's potentially important that the medical folks need to know so they can assist in the preparation and advocacy for the client / patient. And if anybody wants to contact me on this one offline, as you can see, this is something that, again, and some folks have written about this, and I know Bethany knows this, but long ago, the National Center worked with some firms that do a lot of work in professional responsibility. And I believe they came with the very same conclusions over time. And I'm certainly happy to get into that as a matter of more specific and kind of digging a little bit deeper under the surface.
Thanks, Jay. And we'll share contact information in the chat in just a moment. Appreciate Haley posing that question. In the toolkit, there's also some references not to this degree related to the ethical obligations that arise in the attorney-client privilege context. But throughout this series, I think we do have slated some content coming up. So we'll be sure to share contact information for Jay Sicklick, as well as some relevant resources. Thanks, Keegan and Jay.
Yeah, long or not, I think that's great, and I completely agree. Let's move on to the next section, which concerns patient eligibility for MLP services. And I think one of the themes that you should hear coming up is that these are opportunities to have conversations and then to document the conversation. If you are an LSC organization, you may well feel like you have to pull in those requirements in assessing eligibility for your MLP work. I know other LSC organizations that have carve-outs and say, well, this department, whatever it is different. It's funded differently. It has different rules, and so we're going to use those. Here's the point: have the conversation. If you have restrictions, if there are patients that you want to focus on, clients that you want to focus on, right? Define that subpopulation and make sure you spell it out. I think this is also a great opportunity to have a conversation around conflicts of interest, because it may not be a conflict for the pediatrician to have mom bring kiddo in one time and dad bring kiddo in the next time, even if they're divorcing. But for you and the legal team, that could create complications. So, you want to ensure that you're being fair in representation, but also that you are explaining that your professional values and your responsibilities here may not align, and then that helps you get to alignment. Types of legal matter are another piece that are commonly included in this section, because it may be that you are focused on families experiencing homelessness, or you're focused on people impacted by substance use disorder, the opioid epidemic, or whatever. So, and then you're cabining your legal interventions around that. Write that down. Let's be really express about what that looks like up front. The other things that are noted here that I would highlight are recognizing that the legal services organization is very likely quite connected to the community. It's quite connected to the rest of the social sector. And so there may be times where they say, we don't do this because this excellent organization down the street does. So let us do a warm handoff. We already have that relationship, and we can bring that to the healthcare center. So writing all of that out, writing out what you're going to do if someone doesn't meet the eligibility criteria, that is the opportunity here. And yes, I apologize. I used an acronym and didn't spell it out. Legal Services Corporation. It's the federal agency that controls a lot of legal services organizations, but by no means all. Okay, let's jump to the next one. No, feel free to jump in, Jay. I wanted to, no, okay. So plan for evaluation of metrics. This goes back to that conversation that Jay and I were having about reporting, because I think this is another opportunity to talk not just about what this is a responsibility of the legal partner, but that both entities as collaborative organizations can think about how you define success. How do you define progress? What is the contents of that reporting expectation, et cetera, right? These are provisions that can be included. It may be, especially to continue to answer the question about specific terms for a pilot, it may be that you choose not to be specific here. It may be that what you want to say here is that we're going to jointly work on establishing metrics and evaluations, and that's going to be a continuous quality improvement process, right? We're going to be really agile about that rather than trying to kind of waterfall what this looks like up front. I think that's totally fine. The important part is that you establish that expectation, that's a joint priority. That's also really, really key to achieving sustainability. If you don't do anything around this space at all, I think it leaves room for one or the other partner to feel at the end like they weren't valued, like they're not getting anything out of this relationship. So I really, really encourage you to include these provisions and either decide, here's the things we want up front, or we're gonna work on this continually, and here's the process for doing that. Regardless, revisit it, right? None of this that we're saying should ever be as though we're written in stone.
Yeah, I would add, Keegan, that this is one of those variables that very much depends on the amount of resources that the project is able to bring to bear at the outset or potentially down the line, because evaluation is by definition, it's a heavy burden. It's a big load to carry, especially for folks who are kind of mired in the day-to-day work. So, the point I'm trying to make is, does the health center entity already have the capacity and the ability in its own kind of daily operations to handle data collection, metrics, outcomes, processing of that information? And if that's so, or if it's for example, a large academic medical center, maybe those are built into some of the systems that are available to the partnership. If it's a smaller type arrangement, that's going to be a heavier lift. So maybe, as Keegan said, by definition, you want to be more vague, but still include the opportunity to plan for and develop a evaluation plan by perhaps a set certain date, or to then have a standing committee on evaluation, something like that, that at least gets it out the door and into the operational memory, or perhaps better said, the operational workings of the partnership in the first year or 2 years, et cetera, et cetera. So it's an important scenario, and a lot of it will depend on the age, the maturity, and the resources, because those of you who have potentially sought out independent third-party evaluators to give you a potential read on what's going on in a project know that it doesn't come cheap, and it's going to be, again, something that you could potentially build into the budget down the road, or work to obtain jointly a grant from a health involved foundation that will gladly potentially look at metrics like health outcomes, equity issues, et cetera. And that's where that comes in. But I agree, putting something in at the outset is certainly valuable. Certainly having nothing in there does no one any good, and it could jeopardize you in the long run if you go back and say, well, we need to do this now, and you're like, well, we don't have the capacity. So academic partners, always important, because those can drag in, I don't mean by any means pejoratively, but they can bring in, probably a better term, the experts, the public health experts, right? Those are the folks who do evaluation and look at criteria for health outcomes as a daily activity. And those folks can be, even as consultants, really important.
So speaking of funding, I think that's the next component. Oh, no, it's a later component. If we could go to the next slide. Oh, no, I was correct. It is the next component, and I think those are sometimes related topics. I think that it's really important to be really express about who's funding what, who's paying for what, and what those activities look like. For me, this comes back to this document. I am going to take the lawyers in here back to contracts 1L year. Right, it's offer, it's acceptance, it's consideration. That's what makes a contract, and very often the consideration is money. And so if there's money being exchanged here, being express about what that looks like is going to be helpful for everyone feeling like their expectations are met. That might include payment schedules. It might include invoice requirements. Who gets that invoice? How is the money going to be transferred? Et cetera. It can be helpful to include your budget here as an addendum, or to make reference to it as an addendum. The other thing that when I'm helping build these, always recommend be included is some kind of clause that recognizes inflation. Some entities may prefer to think of it as a cost of living adjustment. I have found that inflation tends to resonate a little bit better as a phrase, and they functionally mean the same thing. The goal here is to not have a document that keeps the funding flat for 10 years, and now the partnership can no longer fulfill its obligations. Because the cost of $1 has changed, right? Or what you can buy with $1 has changed. So, really the takeaway there is, although you should be revisiting your MOU very regularly, just in case not, make sure you include some space for costs to go up. What did I forget, Jay?
No, nothing. I think, this is an important language that may evolve and may morph over time, right? Depending on the parties and who's going to be responsible for the funding, which again, we talked a little bit about that last session, so we're certainly not going to go back into that. But at the very beginning of the project, there, the responsibility may be split. It might be one entity, it might be the other. But as things mature, then maybe the language is changed. That's why the first point is it's highlighted a little bit, because I firmly believe that all parties should be responsible for collaborating and cooperating, but ultimately the responsibility of who's going to fund the project is going to be up to your particular situation, and you've probably already determined that. So, if you're just starting out, it might be a grant, and then it might fall on the legal folks. If you're a little bit more down the line and you have a track record, maybe the onus is on the health center or the health entity, and they're going to fund it as part of the responsibility they have in the larger picture. So be open to whatever works for you. But the reason why this was left pretty significantly vague on the top was for that very reason. But feel free to obviously put in the responsibility where and upon whose shoulders that this will bear.
Keegan and Jay, before we move on, we have another comment / question in the chat. So here it is. Our MLP has been deterred from reviewing the MOU very regularly because the document tends to get stuck in one of our larger entities, legal departments, for several months at a time. Does anyone have advice on regularly updating the MOU and ensuring that it moves through the legal departments without hold?
Yeah, I mean, that's tough. I can tell you there's a reason we're both taking a breath, and it's because we've all worked with that department. Right? The department that just feels like their job, like their job is to say no, is to be a roadblock, and that can be really frustrating. Do I have advice? I'm not sure I do, other than I think it makes it all the more important that you are inclusive when you draft your initial MOU, and that you do so in a way that allows space for growth without, and that maybe removes some of the need to revisit the document in the future.
Yeah, Haley, I wish I had a really good answer for you. A part of it may be to, start the process earlier than you would ordinarily expect to try to get it in the pipeline. And it is not uncommon, I think, for some to take longer than others. That's no solace to you. But I think that, it's the relationships you build with the key people that can hopefully push this through, and then someone can, kind of carry it over the goal line. The thing that, had frustrated us for the longest time was actually getting paid, because the invoices, especially to academic folks or universities that run larger entities, those are the things that usually kind of drive you, to the point where you're extraordinarily frustrated. So it's unfortunately, it's part of the bargain sometimes when you have these, institutions that are dealing with obviously multiple things going on at one time. But I don't think there's I don't think there's a lot you could do. It doesn't make sense to put a clause into the contract that say if you don't do this by a certain time, there'll be like an escalator clause or one of these other things that I remember back from, many years ago. I think you just have to kind of grin and bear it and hope to kind of work through it.
And Keegan and Jay, I'll just add, just to reiterate what I put in the chat that Jay also mentioned, as we are at NCMLP working with a very large system to support their MLP development and implementation, and their system involved local entities that operate very independently. It was very, very important before launching that project that MLP, the concept, mechanics, the reason why, everything related to what we were aiming to achieve together was socialized well before we ever launched. And that included the leadership, from general counsel to all the administrative champions within, to ensure that they were on board before the contracts with the ink ever came in front of their eyes. Because sometimes it's just a matter of, what that boils down to, sometimes it's just a matter of understanding this concept and what you're really aiming to achieve, rather than a contractual matter that, general counsel really seeks to hold up. Often just socializing the concept in advance can help, but indeed, you're not alone. Sometimes, yes, we lawyers can slow things down.
Yeah.
Keegan and Jay, back to you.
Thank you. Yeah, and I think the other reason, I think you have to get at the reasons for why it's being slowed down. General counsel probably identifies as a health law attorney in a way that is different than the way that MLP attorneys identify. They're not necessarily experts in what you do, and so being prepared to educate is, I think, also really important. So let's go to the next provision.
One more quick thing, Keegan, on the previous one. Sorry, I don't mean to belabor this, but this is also an opportunity. If you just go back to the previous slide, who's ever on this is your opportunity here to, in addition to, some of these more general provisions, is to talk about what's the schedule of the invoices, what's the payment options, requirements, means, and attaching a budget as a addendum is an important part here, so that the specifics of this agreement are memorialized. So just remember this again. This is, is this going to be quarter again? Is this the kind of stuff that you run around screaming you've got a great victory on? No, but we want this to be quarterly billing. We want it to be every 6 months. We'll run it in the fiscal year corresponding to the health entity or whatever it might be. But these are important parts to remember. And how is the payment going to be made? Is it going to be made, by electronic means, by whatever it is? So those are just things. I'm sorry to add that on, but those are the smaller points that should probably go into the terms, and I think are really important.
Yeah, those are the things I opened with. So let's go to the next section so that we can not make sure we get through them all. So communications, thinking about workflow and processes can be an important conversation to have and then to memorialize in your MOU. I think particularly around the ways that you will share information both at the individual level but also at the organizational level is an opportunity here. And more than that, how you're going to use that to engage in quality improvement. How does that shape the next iteration of your partnership? So maybe I want to keep things moving. If there are other clauses that people have included here or questions that you have, please feel free to jump in. This last, well, it's not really the last one, it's the last piece of the toolkit. We've got some bonus material for you today. Is to include the beginning and end date of the MOU. It may be that you have an MOU that doesn't have an end date. That isn't, I mean, that's a good thing, right? An indefinite commitment, but you can't use that lack of end date as a reason to not revisit the MOU, assuming you have a partner who's willing to timely do that. The other way I've seen these written are with language that kind of evergreens the contract, as we lawyers say. So it'll auto renew as an agreement. In terms of a pilot, I've been holding on to that question. We saw it in the chat. I think this is the place where you'll see the big difference, is probably defining exactly what the terms of the pilot are is part of the term part of the MOU. I will say I like to put this up front at the top, right underneath the recitals. But it certainly makes sense at the end as well. Regardless, if you're running a pilot, spell out what that is and then spell out what the next thing looks like. Here's when we're going to come back and revisit this. Or here's what, maybe if the pilot's deemed successful, we're going to let this auto renew. So that language may shift in part if it's a pilot. Termination, because funding can be variable for these sorts of partnerships, unfortunately, having clear termination expectations is really important. That can help both parties feel like they're not committing for all of time, and it can be a way to have recourse if someone breaches the agreement, if it's just not working out and you need to pivot. Jay, did you have other
No, again, these are pretty common. There may be there may be one clause for on anybody's discretion, but there may be for cause another time frame. So these are pretty standard contract languages. My sense is the healthcare entities probably have these written in already to many of their other agreements, so they'll probably just transfer them into this, and those are always negotiable, by virtue of the fact that this is a very different kind of partnership.
I think that's right. Okay, so we kind of put our heads together and we both have set up a number of MLPs over the years, and so there were a couple of other clauses that we wanted to highlight. I think a lot of these may help with conversations with general counsel if they're being a little bit sticky or hard to pin down. So one is on the next slide. And it concerns what happens if there's a vacancy. If you have a dedicated person or ideally team of MLP legal professionals, and you find yourself without someone in that role, what happens? Particularly if the healthcare entity is paying for it. I have found that if you have that conversation up front and then spell it out in the MOU, that can help clear up and avoid understandings in the long run. So here's some sample language that I have used, right? Should this position become vacant, we're going to extend the grace period because it takes time to hire. Sometimes it takes a very long time to hire. And we're going to do that hiring according to the process that we already put in the MOU. But we want to recognize that, you know, the services probably aren't being dropped entirely. Instead, they're falling to the plates of people who are in, you know, not dedicated necessarily to the MOU, but who help make, I'm sorry, to the MLP, but who help make the MLP happen because they're in a different department, and they're still taking those cases, and that should still be funded work. And I think it's really important to have that express expectation up front. So let's go to the next one. Jay, do you want to
Yeah, happy to do that.
tackle this fun language?
Yeah, so those of you who are not lawyers, please don't crawl into some hole that's near and dear to your computer, because it will make you do that. And we're not going to spend a ton of time on this because this is really into the legal weeds. But in all of the agreements that I was participatory and probably a number of you have as well, have hold harmless and indemnification clauses. And basically, what it means is that, you know, it shifts the risks and the costs from one party to another if there's some kind of liability that's incurred. This can be a big deal, and it can be a little bit frightening, especially legal service entities tend not to, you know, get involved with hold harmless and indemnification clauses in most of the kind of day-to-day business. But they're usually part and parcel of a healthcare entity's kind of mission to create you know, pockets where they're immune from liability, or at least they get reimbursed if there's liability that comes to the fore. So traditionally, and again, Keegan and I have had some interesting discussions, and I put that in quotations, by the way. It wouldn't be interesting outside of anything other than our conversation, but it was interesting in the fact that the contracts that I had worked on over the years were one-way indemnification clauses, and I didn't have a problem signing them. My entity did not. But basically, if we did anything that created some liability, we would have to indemnify the health care entity. It sounds like you're a freak out moment to begin with, but it's one of those things. You take a step back. The opportunities for these kinds of potential liability risk are few, far between, and almost non-existent. But Keegan had a really good point and taught me, I think, about the potential for a mutual indemnification clause, so that the legal service entity isn't on the hook if something happens and people identify the you know, incorrectly the legal service entity for responsibility for, well, hey, that was a medical legal partnership case, and something, a terrible outcome happened to the client/patient that had nothing to do with the lawyer, and the legal service entity somehow gets hooked in for some kind of liability. And so the mutual indemnification clause is important because it protects the back of the legal service entity, whether that's something that will, you know, come to fruition or not, and will be agreed to. Keegan has more experience than I, but again, we never had any problems signing an agreement that had this indemnification language. Never really balked at it, and it's really nothing to be too concerned about. But it's very common in these kind of contracts that happen all the time with healthcare entities.
Agreed. So one more related concept is also going to take folks back to law school if you went to law school. That's the notion of agency. So just a refresher for everyone, or new information if you've never heard it. We have this concept in law of allowing someone else to do things for us. Maybe it's sell a car. It could be even something big like sell a house. Maybe it's take care of a kiddo. Right? We see this show up in healthcare all the time in terms of healthcare proxy, right? So it tends to be something that folks are fairly familiar with. So that's actual agency, right? I've signed a document and I'm saying you can do this for me. And organizations can do that as well. I have seen, particularly when working with hospitals and their general counsel, concern that patient clients won't understand that this is two organizations working together. And that they're separate organizations, and that the hospital or the health center, even, I've seen it with larger health centers too, doesn't control the legal practice, right? That's entirely outside of their control. But what happens if that patient client does file a grievance? Is the medical entity somehow going to be on the hook? And so, an alternative framing for that, or maybe it's an additional framing to the hold harmless and indemnification, is language that says, you know what, we're not, there's no agency relationship here between the organizations. The sample language here also addresses partnership under the Internal Revenue Code, right? We are using the term partners, but we don't mean it in the sense that we're business partners and can make decisions for each other, right? It's another way that agency as a concept shows up. And so this, at some point, just became standard language that I tend to recommend there be a conversation about and then included in the MOU, because it can address some of those concerns that come from attorneys who work with lots of different entities and are kind of thinking big picture about the ways that one entity can create challenges for the other. I will add here that I think including a similar disclaimer in the agreement that the lawyers secure with the client whether it's a retainer, whether it's an MLP specific consent agreement, that, you know, I work for the legal services organization, not for the healthcare entity, can continue to help with that clarification and making sure that the patient client is centered and that they understand what the relationship is also, because it's not often you go to the doctor and end up in a lawyer's office, right? So we always want to be making sure that we're informing our clients, our patients. Okay, last, because I want to, we are coming up on the end of our time together. There may be any number of other kind of boilerplate language that one entity says has to go into all of our contracts. I think we would both encourage you to think about whether it matters. Does the substance of this actually, like, is this the hill you want to die on? And maybe it is something that you need to be really forceful about, but maybe this is just template language. It's the governing law, right? That we're going to follow the laws of the state of whatever. Maybe it's, hey, we really need to know who your registered agent is, and so who to send our notices in. Maybe it is going back to that hiring thing. Maybe it's, yes, we understand, we the healthcare entity understand that you, the legal services organization, are going to do the hiring, but we'd really like to have a line of sight on that and maybe be part of that process, help interview, whatever, right? Maybe it is clarifying that medical records and legal records are two different things. They are owned by each entity, and that, you know, maybe the medical records are accessible, consistent with a minimum necessary standard for the legal team, but that the legal records are never accessible for the medical team or whatever, right? Have those conversations. Don't be afraid of what can feel like really onerous requirements, because a lot of this really is boilerplate, and don't hesitate to reach out to any of us if we can assist with our experiences or with some language around whatever challenge you're having. Jay?
No, I think we can move on to the next one. So again, we've talked a little bit about the BAA. These are required basically to protect health information. It's part of HIPAA, and it basically defines the terms to, you know, to ensure that protected health information remains just that. And there's an indemnification clause almost always in the BAA anyway. So again, you're going to have to sign one whether you probably like it or not. But I don't think it's anything that you would need to be concerned about. It doesn't really, and Keegan and I have talked about this, really kind of, you know, morph into anything that deals with the lawyer-client relationship or anything that deals with the information shared. It's something that's required just as any contractor in the health entity has to provide, because they may come in contact with PHI, protected health information, and it's just one of those things that came up after the Affordable Care Act. And after kind of the revisions to HIPAA, it's just kind of part of the bargain of doing business. And I think that's it for the slides. We have a minute. That's pretty good
More
for us.
questions.
Yeah.
Yes.
That is pretty good. Folks, if you have any questions, and Keegan and Jay, thank you both so much for presenting again and taking questions along the way. And so audience members who've remained with us throughout the duration of the event, please feel free to use the chat or just raise your hand to unmute, and we'll quickly unmute to take a question before we wrap up. As we wait for anyone to take advantage of that last opportunity, let me just ask Reha on our team to scroll through the final slides on resources. As a reminder, this is based on the Health Center MLP Toolkit, which we do believe is applicable across healthcare settings. And so please feel free to, and we encourage you to actually download that toolkit, share it with others, and use it to guide you along in your day-to-day development and implementation processes. And if you are a health center with a specific technical question about how you can integrate medical legal partnership into your health center program, HRSA has asked us to please promote use of BIPIC's contact form for reaching out to ask questions. Rehan, next slide. We have a few, oops, did we get stuck? Sorry, we're all having a little bit of tech difficulties today. So what I'll do is I'll also put in a chat that we have some upcoming resources, as we were presenting earlier on the funding section of the MOU, or excuse me, the evaluation section of the MOU. You all would have seen a note that we have a long overdue upcoming resource that's almost done with the design phase. And that's to provide specific performance measurement tips for health center-based MLP. So we have a performance measures handbook, but last summer we held a learning collaborative that helped us develop some sustainability-focused performance measures and metrics. And so this publication is coming out in just a couple of months. On the next slide, hopefully it advances this time, is a reminder that the webinar series is for this event is being posted on our MLP website. And so there's a link to that page where you can find the recordings, as well as the topics that are coming up on our website for this series. Go to the next slide. The National Center for Medical Legal Partnership will be following up very soon with the date for our upcoming webinar. The next one in the series should focus on what other partners in the community can be helpful. So this one will hopefully highlight the other types of partners that can be involved in a more diverse medical legal partnership, also involving a health center. So maybe you have hospitals in the community that you work with, perhaps in a maternal health focused model that requires a diverse membership or partnership. Let's go to the next slide. And as you can see, we have two really exciting events coming up. So on April 30th, join us as Dan Mistak will be presenting on how to really advance the health equity for justice-involved populations. And then we're launching a brand new learning collaborative in partnership with the National LGBTQIA+ Health Education Center based at the Fenway Institute to help folks prepare early for Pride Month. And so we're asking folks to join us on a 4-part learning collaborative that culminates in the development of a new spiffy tool to promote LGBTQIA+ health access and equity that is running in the month of May. We at least have a thank you in the chat for the webinar, noting that it was very informative. I would ask folks to please help us know more about how helpful this webinar today was and what else we can do to fulfill your TTA or training and technical assistance needs. So take a moment to fill out the survey. It's been linked in the chat. And stay tuned for more. Sign up for the MLP update. That's our bi-weekly newsletter so that you can continue to receive news on how to register for upcoming events, as well as the many funding opportunities that are coming up and are available to support your medical legal partnerships. Keegan and Jay, with that, I'm going to close out today's webinar with another thank you to both of you for presenting on this very important webinar series. And thanks to everyone in the audience. We'll see you next time. Bye-bye.